I'm not doing
Get out of the
nothing,
car.
man. No, don't grab me now.
You're about to go to jail.
Don't grab me, man.
Get out of the car.
Come on, don't do me like that, man.
Get out of the car.
I want to talk to somebody, man.
Get out of the car. You can talk to them when they get here.
Get out. Hey, y'all see this bullshit, man. Man, come on, man.
Don't do it, man.
Fuck y'all, man.
The patrol lights do not announce danger. They announce interruption. A brief disruption in an otherwise ordinary night, the kind of stop most drivers expect to end with a warning, a citation, or nothing at all. The driver responds accordingly. He remains seated. His tone is calm. His hands are visible. There is no urgency in his movements, no agitation in his voice. Everything about the opening seconds suggests predictability. But predictability is not what the officers are interested in. From the outset, the interaction drifts away from the stated reason for the stop. The questions stretch outward, where the driver has been, where he is going, who he knows, how long he has lived nearby. None of this clarifies the alleged violation. It builds a profile. The officers are not resolving a traffic matter, they are constructing context. And context, once assembled, becomes leverage. The driver cooperates. He answers plainly. He does not hedge or deflect. This transparency should narrow the encounter. Instead, it widens it. Each answer invites another question, another pause, another recalibration of suspicion. The officer's attention lingers, not on the vehicle, but on the person inside it. This is the first quiet shift of power. When the conversation turns to the driver's past, the tone subtly changes. The present becomes secondary. History begins to color interpretation. The driver does not resist these questions either. He speaks openly about his record, his time away, his work, his family. He frames his life in terms of progress and distance from past mistakes. None of this registers as mitigating. Within this encounter, history is not context, it is cause. From this moment on, the stop is no longer about compliance. It is about assessment. The law allows officers to consider the totality of circumstances. That phrase carries enormous weight. It can justify caution, but it can also justify bias. When used responsibly, it prevents harm. When used opportunistically, it rationalizes escalation. Here, the totality is not built from present indicators of risk. It is built from biography. The alleged violation itself is trivial, a technicality that exists largely on paper, an object hanging from the rearview mirror, a minor failure to stop. These are not danger signals, they are discretionary tools. And discretion is where authority reveals intent. Instead of resolving the stop, the officers begin repositioning it. Their questions persist. Their posture remains alert. The driver is instructed to remain still, then to prepare to move. The inconsistency is subtle but meaningful. It keeps him reactive. It prevents him from settling into a clear role. When the request comes for the driver to exit the vehicle, it is not framed as optional, but it is also not framed as urgent. There is no immediate threat articulated, no visible weapon, no aggressive act. The command exists in a gray space, authoritative without explanation. This is a critical juncture. Legally, officers may order a driver out of a vehicle during a lawful stop, but legality does not dictate necessity. The difference matters. Necessity must be grounded in safety or investigation. Here, neither is clearly present. The request appears less about protection and more about control. The driver questions the need. He does not refuse outright. He asks why. This question is pivotal. It asserts agency. It interrupts the assumed hierarchy, and it changes how the officers perceive the interaction. From this point forward, the driver is no longer simply compliant. He is measured. His words are weighed for tone rather than content. His movements are scrutinized for intent rather than function. The concept of furtive movements enters the narrative here, not as an immediate concern but as a retrospective explanation. The officers reference earlier actions, vaguely defined, difficult to verify, and impossible for the driver to meaningfully contest. The term itself is elastic. It describes without specifying. It suggests danger without demonstrating it. Once spoken, it becomes justification. The driver insists there is nothing in the vehicle. He emphasizes that he has no weapons. He speaks with urgency but not aggression. His voice rises only as the situation tightens. This is not escalation by force. It is escalation by compression, the narrowing of options. The officer's proximity increases. Their commands overlap. The environment becomes crowded with instruction. This is not chaos, it is pressure. The driver is placed in a position where compliance requires immediate physical movement, but movement itself is now suspect. This is the paradox that defines many such encounters. Stillness is interpreted as defiance. Movement is interpreted as threat. The driver cannot resolve it because it is not meant to be resolved. It is meant to justify intervention. When physical force is applied, it is sudden. There is no countdown, no clear final warning proportionate to the response. The driver's body is pulled from the vehicle and driven downward. The transition from verbal authority to physical dominance happens in seconds. At that moment, the encounter crosses an invisible line. Up until now, everything could still be reframed as misunderstanding. After this, it becomes narrative preservation. Once force is used, officers must defend the use of force. The stop is no longer the focus. The justification is. The driver's physical state changes immediately. He is on the ground, he is injured, he is confused. His attempts to speak are fragmented by pain and shock. This is not resistance, it is disorientation. But within the logic of force, disorientation reads as instability. Bystanders begin to notice. Phones appear. The presence of witnesses introduces a new dynamic. Public visibility does not de-escalate the officers, it entrenches them. To retreat now would be to concede error in front of an audience. Authority, when challenged publicly, often responds by hardening. The driver's protests grow louder, not because he seeks confrontation, but because he seeks acknowledgement. He calls out to the crowd, not for intervention, but for validation. This is the human response to sudden powerlessness, to be seen. The officers continue. Their focus shifts from the driver to each other. They communicate in short, procedural exchanges. This is where the incident begins to transform into a case. Language becomes standardized. Phrases are repeated. The earlier ambiguity disappears, replaced by certainty. Charges begin to take shape. The concept of resisting without violence is introduced not as a description of conduct, but as a classification. It reframes the driver's reaction to force as the offense itself. This charge is uniquely effective because it requires no independent harm. It criminalizes noncompliance after authority has already been asserted. From the system's perspective, it closes the loop. Medical attention is addressed, but it is secondary. The driver's injuries are acknowledged without urgency. Pain becomes a logistical issue rather than a moral one. The priority remains control and documentation. The vehicle search follows. It is justified using the same rationale that now underpins everything else. The earlier mention of movements is elevated to probable cause. The sequence is inverted. Force produces reaction. Reaction produces justification. Justification retroactively validates force. This is how escalation becomes self-sustaining. By the time the search concludes, the original stop is irrelevant. The air freshener no longer matters. The technical violation fades into the background. What remains is the official account, a version of events structured to withstand scrutiny. The driver is no longer a motorist. He is a suspect. His earlier cooperation is erased by the narrative now attached to him. The system does not track intention, it tracks outcome, and the outcome has been defined. As the scene stabilizes, the officers appear composed. The intensity drains from their voices, the urgency dissipates. This calm is revealing. It suggests that the perceived threat has been neutralized, not because danger existed, but because control has been reasserted. For the driver, the night is already over, not in time, but in trajectory. Whatever happens next, charges, court dates, explanations to family, will be shaped by what has just been recorded, interpreted, and preserved. This is the quiet truth of encounters like this. They are decided not by the most dramatic moment, but by the earliest assumptions. Once those assumptions harden, every action that follows serves to confirm them. What began as a routine stop was never allowed to end as one. It was redirected, reframed, and escalated until the outcome justified the approach. And once that process begins, it rarely stops itself. By the time the driver is restrained and no longer able to physically influence the scene, the encounter has already entered its second phase. This phase is quieter, more procedural, and far more consequential than the chaos that preceded it. The raised voices subside. The urgency in the officer's movement softens. What replaces it is something colder and more deliberate: narration. This is the moment when force gives way to justification. The officers begin to speak not to the driver, but around him. Their words are no longer commands or warnings, they are explanations. Each sentence serves a dual purpose: to rationalize what has already occurred and to anticipate scrutiny that has not yet arrived. This is not accidental. It is a learned response within modern policing culture. Officers understand that the most important audience is no longer the person on the ground, but the future reviewer. Supervisors, prosecutors, internal affairs, judges. The language tightens. Vague impressions harden into articulated facts. What had previously been described loosely is now framed with legal precision. This is where the narrative begins to calcify. The concept of furtive movements returns, now with weight and permanence. Earlier, it functioned as an impression. Now, it is positioned as a trigger. The officers describe movements that allegedly occurred before the stop was fully initiated. Movements that cannot be independently verified and that conveniently predate the escalation. This timing is critical. By placing the origin of suspicion earlier in the timeline, the officers insulate themselves from accusations of reacting emotionally or impulsively. This is how retrospective justification works. In lawful policing, cause precedes action. In narrative policing, action precedes cause, and cause is assembled afterward. The difference is subtle on the surface but profound in effect. Once written, the narrative becomes authoritative, even if it was formed under pressure or bias. The driver, still disoriented and injured, attempts to assert that he has done nothing wrong. His statements are emotional, fragmented, and repetitive, exactly what trauma produces. But trauma does not translate well into official records. Emotion is interpreted as agitation. Repetition is interpreted as noncompliance. Pain is interpreted as instability. Within the logic of the system, the driver's reactions begin to serve as further evidence against him. The officer's attention shifts to the vehicle. This is not incidental. The vehicle represents both potential evidence and narrative reinforcement. A search that produces nothing can still be justified. A search that produces something validates everything that came before. Either way, the act of searching signals authority. The justification for the search is articulated carefully. Officer safety is emphasized. Potential access to weapons is cited. The earlier mention of movements is elevated from suspicion to probable cause. The driver's refusal to consent, a constitutional right, is reframed as a factor contributing to suspicion, even though refusal cannot legally do that. This is one of the most persistent contradictions in policing practice. Rights are protected in theory, but punished in practice. Exercising them often escalates encounters because they disrupt the expected flow of compliance. The officers speak in a manner that suggests inevitability. The search is not presented as a choice or a discussion. It is framed as a duty. This framing is important because it removes personal responsibility. If the action is required, then the officer is merely an instrument, not a decision-maker. This diffusion of responsibility is a hallmark of institutional misconduct. As the search proceeds, the driver's physical and emotional state continues to deteriorate. He expresses fear. He expresses disbelief. He expresses pain. None of these expressions alter the course of events. Once the system has committed to a path, deviation becomes riskier than continuation. Bystanders remain present. Their cameras capture fragments, angles, sounds, moments, but not the full context. The officers are aware of this. They do not directly address the crowd. Instead, they perform professionalism. Their posture straightens. Their language becomes formal. This performance is not for the public, it is for the record. This is how visibility can paradoxically protect authority rather than challenge it. The driver's repeated insistence that he did nothing wrong does not register as a claim to innocence. It registers as denial. In the criminal justice system, denial is not neutral. It is often interpreted as lack of accountability, even before any determination of guilt. The officer's injuries, minor or otherwise, are discussed with seriousness. This is another narrative pivot. Officer injury, regardless of severity, elevates the incident. It justifies escalation. It reframes the encounter as dangerous. It shifts sympathy. The driver's injuries, by contrast, are contextualized. They are framed as consequences of his actions, not of the officer's decisions. This asymmetry is deeply embedded in institutional logic. Harm to authority is seen as extraordinary. Harm to civilians is seen as incidental. Medical personnel are eventually involved, but their role is limited. They assess, they stabilize, they move on. There is no pause for reflection, no reconsideration of the initial force. The presence of medical care does not trigger accountability, it completes the procedure. As time passes, the officers begin reconstructing the critical moments verbally. They recount how the driver moved, how he reacted, how events unfolded. These reconstructions are collaborative. Officers confirm each other's accounts. Details align, gaps are filled. This process is subtle and often unconscious, but it produces consistency, the single most valuable currency in any legal defense. Consistency matters more than accuracy. Once the story aligns, it becomes resilient. Contradictory evidence must overcome not just one account, but a unified front. This is why civil suits are so difficult. Plaintiffs are often confronting not isolated actions, but an ecosystem of reinforcement. The driver, meanwhile, is removed from the center of the narrative. He is no longer actively engaged in shaping it. His statements, if recorded, will be filtered, summarized, and contextualized by others. His perspective will appear disorganized compared to the polished coherence of official reports. This imbalance is not accidental. It is structural. At no point is there a meaningful reassessment of whether the escalation was necessary. The original violation is never revisited as insufficient justification. The question of proportionality is never asked. The system does not self-interrogate in real time. It documents and proceeds. The charge of resisting without violence becomes central. It serves as the legal glue holding the narrative together. It explains the force. It explains the injuries. It explains the search. It reframes the driver as the source of disorder. Importantly, this charge does not require proof of intent to harm. It criminalizes failure to submit. In doing so, it blurs the line between lawful authority and coercion. Compliance becomes not just expected, but mandatory under threat of criminalization. The officer's internal dialogue suggests closure. They discuss logistics. They coordinate transport. They check on each other. The emotional intensity that marked the earlier moments is gone. This calm underscores a critical truth. The danger has passed not because a threat was neutralized, but because the encounter has been absorbed into procedure. For the driver, this calm is jarring. His distress remains raw. His sense of injustice is immediate. But the system has moved on. It always does. This is where the long tail of consequences begins. The charges will follow him. The footage will exist, but interpretation will vary. The burden of proof will shift onto him to demonstrate misconduct rather than onto the officers to justify force. Even if discrepancies emerge later, they will be weighed against the presumption of reasonableness afforded to law enforcement. That presumption is powerful. It is reinforced by doctrine, precedent, and institutional trust. The driver's past will not help him here. Though legally irrelevant to the incident, it will color perception. It will subtly shape credibility assessments. This is the quiet aftershock of earlier disclosures, honesty that now becomes disadvantage. As the night draws to a close, the scene appears resolved. Vehicles depart. The crowd disperses. The officers return to routine. But resolution is an illusion. What has occurred is not merely an overreaction. It is the activation of a system designed to prioritize authority preservation over error correction. Each step followed protocol. Each justification referenced accepted standards. And yet, the outcome feels deeply wrong. This is the paradox at the heart of modern policing accountability. Harm can occur without rule-breaking. Injustice can emerge from compliance. Violence can be lawful. By the end of this phase, the driver's fate is largely sealed. The narrative is complete. The legal machinery is in motion. Challenging it will require time, resources, and resilience, commodities the system knows most individuals lack. And so, the encounter transitions from a street-level confrontation to a prolonged struggle for recognition, one that will unfold far from cameras and crowds. The second phase ends not with a bang, but with paperwork. And paperwork in this system has extraordinary power. When the patrol cars finally pull away and the road falls quiet again, the incident does not end. It simply changes form. What remains behind is not just a damaged vehicle, torn clothing, or visible injuries. What lingers is a legal gravity that will continue pulling long after the night itself is forgotten by everyone except the person who lived it. For the driver, the immediate shock gives way to something slower and heavier. Pain settles into the body. Confusion settles into the mind. The questions arrive one by one, not shouted by officers but whispered internally. How did this escalate so fast? Where did control disappear? At what point did cooperation become liability? None of those questions will matter to the system now. The system has already moved forward. Reports will be written while memories are still warm, shaped by shared language and reinforced certainty. Each report will mirror the others, not because the officers conspired, but because institutional training encourages coherence. Inconsistency invites scrutiny. Consistency closes ranks. This is the stage where truth becomes less important than alignment. The driver's version of events will exist, but it will exist in isolation. It will not benefit from standardized phrasing or legal framing. It will be emotional, fragmented, human. Those qualities make it sincere, but sincerity does not carry evidentiary weight. Courts do not measure pain, they measure plausibility, and plausibility favors authority. The charges that follow are not dramatic. They do not require headlines. They are administrative in appearance but devastating in effect. Resisting without violence, failure to comply, obstruction. These offenses are designed for moments exactly like this, where force precedes justification and justification needs a legal anchor. They transform reaction into wrongdoing. Even if those charges are eventually dismissed or reduced, their presence alone extracts a toll. Court dates interrupt work schedules. Legal fees drain savings. Employers grow cautious. Background checks do not explain context. They list outcomes. The driver's earlier honesty now follows him like a shadow. The disclosures made during the stop, spoken without legal counsel and without hostility, become part of a record that will never fully disappear. He was not lying, he was not evading. But transparency, once documented, is not neutral. It is stored, searchable, retrievable. This is the irony of rehabilitation within systems that remember forever. The officers, meanwhile, return to routine. The incident becomes a reference point, not a rupture. It may be discussed briefly during review, framed as unfortunate but justified. Any injuries sustained by officers are logged. Any injuries sustained by the driver are contextualized. The distinction is subtle but meaningful. Officer harm is treated as evidence. Civilian harm is treated as consequence. Internal investigations, if initiated, proceed slowly and quietly. They focus on policy adherence rather than outcome. Did officers follow procedure? Did they articulate safety concerns? Did they call for backup? Did they request medical assistance? Each affirmative answer narrows the window for accountability. Policy compliance becomes moral insulation. Bodycam footage, often described as an equalizer, rarely functions that way in practice. It captures fragments but not sensation. It records movement but not fear. It documents sound but not intent. Reviewers interpret it through institutional lenses shaped by deference and precedent. When ambiguity appears, it resolves in favor of the badge. The driver may pursue civil remedies. The law allows it, in theory. But civil litigation is a marathon run against time, money, and emotional endurance. Qualified immunity looms over every claim, narrowing the path to relief. Plaintiffs must demonstrate not only harm, but that the harm violated clearly established rights under nearly identical circumstances. Nearly identical is a high bar. Every factual discrepancy becomes an obstacle. Every emotional reaction is scrutinized. Every prior mistake resurfaces. The driver's life is opened and examined in ways the officers' lives are not. This asymmetry is not written into statutes, but it is embedded in practice. Justice, in this framework, is conditional. As months stretch into years, the incident recedes from public memory. There is no viral clip replaying endlessly, no sustained outrage, no national reckoning. Without spectacle, accountability withers. The driver carries the memory alone, replaying moments not for clarity, but for self-blame. Could he have spoken differently? Could he have moved slower? Could he have said less? These questions are corrosive because they assume the burden of prevention belonged to him. The deeper truth is more unsettling. Once the encounter crossed a certain threshold, individual behavior no longer mattered. The machinery had engaged. Every action afterward served to justify what had already occurred. The driver was no longer steering events, he was being carried by them. This is how systems absolve themselves. The officers may genuinely believe they acted reasonably. Belief is not irrelevant. It is precisely what makes systemic failure so resilient. When individuals perceive themselves as compliant with rules, they are less likely to question outcomes. Harm becomes collateral rather than intentional. But collateral damage is still damage. The driver's children will not read policy manuals. They will see bruises. They will hear stories filtered through exhaustion and restraint. They will absorb a lesson about authority that no civics class teaches, that compliance does not guarantee safety, and that explanation does not guarantee understanding. This generational impact rarely appears in reports. Years later, if the case concludes, the resolution will feel incomplete. A settlement does not equal vindication. A dismissal does not erase trauma. Even a courtroom acknowledgement of wrongdoing arrives too late to restore what was lost in that moment of sudden force. Time, in these cases, does not heal. It dulls. The officers' careers continue largely unchanged. There may be training reminders. There may be procedural memos, but the fundamental incentives remain intact. Discretion is still broad. Accountability is still rare. The same legal doctrines still govern the next stop and the one after that. Nothing structural shifts. This is why incidents like this recur without pattern recognition. Each is treated as isolated, contextual, unique. Patterns are denied not because they do not exist, but because acknowledging them would demand reform that threatens institutional stability. Stability is prioritized over justice. The driver becomes a statistic, if he is counted at all. His case may appear in a database, stripped of narrative, reduced to codes. The fear, confusion, and pain that define the night are not searchable fields. What remains searchable is the charge. The Bodycam footage will sit in digital storage, accessed occasionally, interpreted selectively. It will not speak on its own. It never does. Footage requires framing, and framing reflects power. This is the quiet ending of most accountability stories. Not with resolution, but with absorption. The system absorbs the incident, neutralizes its threat, and continues forward unchanged. For the driver, moving forward means carrying something invisible but heavy. Every police light in a rearview mirror will feel different now. Every interaction with authority will carry the memory of how quickly control can be taken and how slowly it is returned. This is not paranoia. It is adaptation. The most troubling aspect of this story is not that it happened. It is that nothing about it surprised the system. Every step fit within expected boundaries. Every justification had precedent. Every outcome had a pathway. That is what makes it dangerous. When harm fits neatly inside policy, it becomes difficult to challenge. When injustice is lawful, it becomes invisible. And when authority is rarely required to confront its own excesses, excess becomes normalized. The sirens fade, the reports are filed, the case moves on. But for one person, the night never fully ends. It echoes in the background of daily life. A reminder that power does not need to announce itself to be overwhelming. It only needs permission, structure, and time. And in this system, it has all three. Long after the legal paperwork has been filed and the memory of the night has faded from institutional consciousness, the structure that produced the incident remains intact. That is the final, uncomfortable reality. Not that something went wrong, but that nothing within the system requires it to go right next time. The same discretionary space exists. The same incentives remain. The same outcomes are quietly anticipated. This is not a failure of individuals alone. It is a failure of design. Policing systems are built around forward momentum. Stops must conclude. Calls must clear. Reports must be written. The apparatus does not pause to ask whether an interaction should have occurred in the first place. It asks whether the interaction can be justified after it has occurred. This backward-facing logic ensures continuity, not reflection. In this framework, learning is optional. When officers review incidents like this internally, the focus is rarely on decision points. It is on compliance with procedure. Did officers announce commands? Did they call for backup? Did they request medical assistance? Did they document their reasoning? These questions are easier to answer than the harder ones. Should this have escalated? Was force the least intrusive option? Was suspicion grounded in observable behavior or assumption? The harder questions threaten stability. As a result, training often reinforces the very behaviors that generate conflict. Officers are taught to trust instinct, to control space, to dominate uncertainty. They are warned that hesitation invites danger. In this mindset, de-escalation becomes counterintuitive. Slowing down feels risky. Letting go of control feels unsafe. The paradox is that this approach often manufactures the danger it claims to prevent. The encounter began with ambiguity, not threat. It escalated because ambiguity was treated as hostility. The driver's uncertainty was interpreted as deception. His questions were interpreted as resistance. His attempts to explain were interpreted as deflection. Each interpretation narrowed the officer's tolerance for anything other than immediate compliance. This narrowing is not accidental. It is trained. Officers are rewarded implicitly for assertiveness, decisiveness, and command presence. They are rarely rewarded for patience. There are no metrics for restraint. There are no citations for stops that end quietly because someone chose not to escalate. The system tracks action, not absence of action. So, action becomes the default. When incidents like this reach the public eye, responses often focus on optics. Departments issue statements emphasizing policy adherence. Officials reassure communities that procedures were followed. The language is soothing, but it is also revealing. It suggests that the primary concern is reassurance, not reform. Reassurance preserves trust. Reform threatens authority. This is why patterns persist. Each case is isolated, contextualized, and closed. Data is fragmented. Stories are disconnected. Without aggregation, there is no pattern. Without pattern, there is no problem, and without a problem, there is no urgency. The driver's experience becomes anecdotal rather than evidentiary. Even when lawsuits succeed, their impact is limited. Settlements are paid without admissions. Policies are reviewed without revision. Training modules are updated without cultural change. The system absorbs the cost as a line item and continues operating. Financial consequences rarely reach decision-makers. Qualified immunity further entrenches this dynamic. By shielding officers from personal liability unless conduct violates clearly established law under nearly identical circumstances, the doctrine narrows accountability to extremes. Novel harm is excused precisely because it is novel. Repetition is required before clarity emerges, but repetition harms people. This creates a perverse learning curve where the system learns only after damage has been normalized. Civilian oversight bodies, where they exist, often lack teeth. They can recommend, but not enforce. They can observe, but not intervene. Their findings are advisory, not binding. This structure allows departments to claim transparency without surrendering control. Transparency without consequence is theater. The driver, watching from the outside, sees a process that moves without him. Meetings occur behind closed doors. Decisions are communicated through legal language. Time stretches, momentum fades. The urgency he feels is not shared by the institution. This asymmetry is exhausting. As years pass, the incident becomes part of the driver's identity in ways he never chose. He becomes cautious. He becomes guarded. He avoids situations that might draw attention. He learns to read authority differently, to anticipate escalation where others see neutrality. This adaptation is rational, but it is also costly. It reshapes behavior not through trust, but through fear. Meanwhile, the officers involved may barely remember the incident. It blends into a career filled with stops, calls, and reports. Without accountability that marks the moment as exceptional, it dissolves into routine. The lack of consequence teaches a lesson as clearly as any reprimand would. It teaches that escalation works. This is the quiet curriculum of modern policing. Not written, but demonstrated. Not stated, but observed. When force resolves uncertainty and produces defensible outcomes, it becomes normalized. When restraint feels risky and unrewarded, it fades. Over time, this shapes culture. Culture, more than policy, determines outcomes. Policies can mandate de-escalation, but culture decides when it is applied. Policies can require articulation, but culture decides how truthfully. Policies can promise accountability, but culture decides whether accountability is feared or ignored. In this case, culture won. The system's greatest vulnerability is not misconduct, it is predictability. Once patterns are recognized, trust erodes. Communities learn what to expect. Individuals adjust behavior not to comply with the law, but to survive encounters with it. This erosion is slow and often invisible to those inside the institution. Officers see compliance. Civilians feel coercion. Both interpret the same interaction differently, and the gap widens. Bridging that gap requires more than cameras and lawsuits. It requires structural humility. It requires limits on discretion. It requires incentives that reward restraint. It requires consequences that reach beyond settlements. Most of all, it requires acknowledging that harm can occur without malice. The incident did not require bad actors to unfold. It required ordinary decisions made within a system that privileges control over understanding. That is why it is so difficult to prevent. Removing one officer does not change the framework that guided him. Reform must address that framework. Until it does, the next stop will look familiar. The questions will expand. The assumptions will form. The commands will overlap. The moment of force will arrive suddenly, and afterward, the justifications will align neatly on paper. The driver's story is not unique because the system does not need uniqueness to function. It needs consistency. Consistency ensures survivability. As long as accountability is rare, escalation is rational. As long as discretion is broad, bias finds space. As long as authority is insulated, harm is absorbed rather than corrected. The system learns nothing because it is not required to. And so, the final truth is not that this incident was tragic, though it was. It is that it was instructive. It taught the system that it could proceed as designed and emerge intact. For the driver, the lesson was different. It taught him that safety is conditional, that rights are fragile in practice, and that explanations do not always protect. These lessons coexist uneasily, shaping future encounters in opposite ways. The system moves forward unchanged. The individual carries the weight. That imbalance is the real ending. Not a verdict, not a settlement, not an apology. An understanding that without structural change, the next siren will fade just as quietly, and the system will once again learn nothing at all.